For weeks this spring, the world watched as Meriam Ibrahim, a pregnant Christian woman in Sudan, faced flogging and the death penalty because her government would not accept that she had lived her life as a Christian and married a Christian man. Meriam has demonstrated both courage and grace under pressure, giving birth in jail in May, while chained and caring for her two children, including her newborn, not only under restraints, but without the normal amenities that any pregnant woman and nursing mother should expect. The harsh application of Sharia law on non-Muslims was the trigger, and everyone knows this, for the 2-decade-long civil war in Sudan that eventually led to the secession of the South. Sudan is one of 20 countries in the world who have laws against apostasy, defined as the abandonment by an individual of their original religion. In Sudan, apostasy is effectively considered leaving the Muslim faith, particularly the interpretation of Islam followed by authorities there. In Sudan, to leave the Muslim faith is an automatic death sentence. If you are considered an apostate, you cannot legally marry someone of another faith, and for this, Meriam was also charged with adultery and sentenced to flogging. However, this story is not just about harshly applied religious and legal principles in violation of national and international law. Daniel Wani, Meriam's husband, is a Christian who is a dual American and South Sudanese citizen. He has lived in the United States for more than a decade. He married Meriam in late 2011, and they had a son a year later. Somehow, the U.S. Embassy in Khartoum could not find a way to help bring this American to get his family out of Sudan before the crisis developed, even after she was arrested and released last year on charges of involving apostasy. Today's hearing is intended to examine the facts as we know them and to determine how strictly applied rules almost led to the officially sanctioned beating and execution of a young woman who has lived as a Christian all of her life, but who has now been told that she has no right to choose her religious belief. This hearing was originally scheduled to take place in June, but at the urging of Sudanese officials and Mark Meadows, who has been doing yeoman's work on this issue, and some in our government, we postponed it to allow for quiet diplomacy to take place. However, Meriam's legal entanglements seem to be increasing now rather than diminishing. We intend for this hearing to be a strong appeal to the government of Sudan to use their legal authority to end the official entanglements Meriam has faced since her arrest in January and subsequent trial. A Sudanese court initially ruled that the mere fact that her father was Muslim means that she should have been raised as a Muslim. She was given 3 days to convert to Islam, but she told authorities she would not abandon her Christian faith. Her refusal to leave the faith she had practiced her entire life led to her being in mortal fear for her life. Fortunately, a Sudanese appeals court believed that she considered herself Christian and overturned her conviction on apostasy and adultery charges. However, members of her family, allegedly, have appealed the overturning of her conviction. Meanwhile, the government of Sudan rearrested Meriam for using South Sudanese documents in an attempt to leave the country, and while she was released on bail, that case is still pending. Finally, Meriam's family has filed a case in domestic law court to establish that she is Muslim and that her brother, who was unable to prove his legal connection in the original apostasy adultery case, should be her legal guardian under Sharia law. The hearing date for at least part of that case is currently set for August 4th because she was not given a written summons to appear at a July 17th hearing on the matter. We cannot be absolutely certain of the exact chain of events that led to this situation. The Department of State understandably decided not to testify at this particular hearing, although this will become a hearing in a series of hearings until this is resolved. Daniel and Meriam are still in Sudan at this point, and we will invite the State Department to give a full accounting and any insights they might want to provide. Daniel and Meriam are still in Sudan, as we all know at this point. Daniel is free to leave with his children, but has chosen, of course, to stay with his wife until she, too, can leave with her family. Since Meriam's conviction in May, a bipartisan bicameral congressional coalition has worked tirelessly to undo the harsh penalties for her under the apostasy and adultery laws and to secure her family's repatriation to the U.S. Contact was made with Daniel, as well as the U.S. Embassy in Khartoum and the Sudanese Embassy right here in Washington. Eventually, the headquarters offices of both State Department and U.S. Citizenship and Immigration Services got involved. Yet one wonders why this matter had to come to a crisis stage before a means could be found to avoid what now seems to have been an inevitable outcome in this case. Daniel told congressional staff that he sought help from the U.S. Embassy in Khartoum, but was told that he should seek an attorney, since the situation was mostly focused on his wife, who was not an American. This was the advice he received even when he was arrested and had his passport seized. An American citizen should expect more, I believe, from his government's representatives in a foreign country when the country's government has taken action against them. Sudanese religious do not have the right to force someone to be Muslim when they assert their beliefs to be otherwise. Under the principles of natural law, which are the basis of our governing documents and those of countries around the world, there are certain inalienable rights endowed by our Creator. The decision on how to worship our Creator is one of them. Elements in Sudan's Islamic clergy and in the government interpret the Quran to give them license to tell people how they will live out their faith, whether they consider themselves Muslim or not. In Miriam's case, her father had been absent from her life since she was a small child. Her Christian mother raised her as a Christian. Sadly, Meriam is not the only Sudanese who chose differently on the matter of faith, only to be faced with a death sentence for that choice. Sudanese activist Mahmoud Mohammed Taha was arrested and charged with apostasy in 1984 for his efforts to end Sharia law in Sudan. He was subsequently executed. In some countries, Christian converts have been forced to renounce their faith and conform to the version of Islam favored by the government of that day. Some of these countries have constitutions that ostensibly guarantee religious freedom, even as they may also have laws that actually contradict those rights. Except for Malaysia, Oman, Qatar, Saudi Arabia, and the United Arab Emirates, the other 15 countries, including Sudan, have signed the International Covenant on Civil and Political Rights, guaranteeing freedoms for their citizens. Article 18 of that document enshrines, quote, the right to freedom of thought, conscience, and religion. Speaking of the rights of the individual, that article also forbids coercion, which would impair his freedom to have or to adopt a religion or belief of his choice. Article 18 also guarantees the freedom to have or to adopt a religion or belief of his choice and freedom to either individually or in a community with others and in public or private to manifest his religion or belief in worship, observance, practice, and teaching, close quote. The current report by the U.S. Commission on International Religious Freedom cites Sudan as a country of particular concern due to its government's engaging in systematic, ongoing, and egregious violations of freedom of religion. According to USERF, Sudan is the world's most violent abuser of the right to freedom of religion or belief. Thankfully, we have the author of that law, the International Religious Freedom Act, Frank Wolf, who back in 1998 authored that landmark legislation. And today, testifying, we have Zudi Jasser from the Commission, who recommends in his testimony that not only should the U.S. government take appropriate actions against Sudan, as detailed in IRFA, but that our government should also make freedom of religion and human rights a centerpiece of U.S.-Sudan bilateral relationship, as that has not been the case to date. The troubling case of Meriam Ibrahim should warn of future incidents in which those who do not believe in Islam are defined by the government, are persecuted or placed in fear of death or torture. We again appeal to the government of Sudan to use all legal means at its disposal to free her, this courageous young woman, and allow her to pursue her faith and join her husband in the United States. I'd like to yield to a friend and colleague, the ranking member, Mrs. Bass.